Take a look at a key case in tort law for occupier's liability. This case is English Heritage v Taylor, which was heard in 2016. The claimant in this case was Mr. Taylor, who was the husband of the deceased, and the defendant was English Heritage. The deceased was visiting a castle at an English Heritage site. He was walking along a grass slope on an informal path when he fell off the slope and into a dry moat, causing serious injuries. There was no warning sign of the 12-foot drop down to the moat, and the size of the drop was not visible to the deceased due to the landscape of the castle. The English Heritage was found liable and ordered to pay compensation to the husband of the deceased, Mr. Taylor. This is because the sheer drop was an obvious danger and the defendant should have taken reasonable steps to protect visitors of the premises. English Heritage were in breach of their duty by failing to provide an adequate warning sign. However, while the defence of a warning sign could not be used here, this case is an example of the defence of contributory negligence being used. The defendant was successful in raising the defence due to the deceased walking on an informal path which was seen to contribute to their own death. This resulted in a 50% reduction to damages awarded to the claimant. In an exam scenario, if there is an obvious risk and no warning sign, then liability would usually follow, as an obvious danger such as this requires a sign. The sign would need to be specific of the dangers to be used successfully as a defence.